appeared in the matter of Great Asia Maritime Ltd and Orion Shipping Trading.
Morning.
Good morning, may it please your lordships. I appear on behalf of the Appellant Great Asia Maritime Ltd together with Ms Eliza Bond. My learned friends Mr Alex Wright and Mr Robert Scrivener appear on behalf of the Respondent Orion Shipping and Trading Limited. I intend to divide my oral submissions this morning into three sections. One, brief introductory comments. Two, to take your lordships through the MOA and the award. And three, to make substantive submissions on the two grounds as to why the judgment was wrong and the appeal should be allowed.
Just to let you know, we've obviously read in quite extensively, including quite a lot of the authorities, and obviously looked at the MOA very carefully. But that's not in any way to discourage you from looking at it very carefully too.
Maybe we can take it at a canter.
Also just to say that we're going to take just a very short mid-morning break halfway through.
Can I ask something else? Is there a transcript by any chance or not?
I don't think so.
No, it just affects the detail of a note, I take it. That's all. There's no obligation to provide us with a transcript, but it's just if
Understood. Thank you.
Thank you.
Section 1, Introduction. There are two key issues corresponding to the two grounds. The first issue is whether the sellers were under an obligation to tender NOR and be ready to validly complete a legal transfer of the vessel by a particular date. At present, there are up to three answers to that issue in play. Answer 1, we say, the answer is yes, sellers were obliged to do those things by the cancelling date. Answer 2, sellers say, and one sees this in paragraph 20, sub 3 of their skeleton at core, page 60, leaving aside the laden voyage clause, sellers are under an implied obligation to deliver within a reasonable time. We understand that to presuppose obligations to tender NOR and be ready to validly complete a legal transfer within a reasonable time. Presumably the factual inquiry as to what is a reasonable time in any given set of circumstances would ultimately lead to a particular date. Answer 3, we say, is in the judgment, where Mrs. Justice Dyer says in paragraph 15 at core, page 86, that there was no positive obligation to tender NOR nor be ready to complete a legal transfer by 20th August 2021 or any other date. At face value, that would appear to preclude a positive obligation to do those things within a reasonable time. Perhaps the sellers will defend that passage on the basis it is dealing only with the express wording and does not rule out their implied term.
Well, if literally true, it would mean it wouldn't be a contract of sale, would it? It would just be an option.
Yes. So, leaving to one side where the seller's position is different to that of the judge, we say that sellers have conceded there must be some deadline because it's not an option. It is an outright contract of sale, as is indicated in clause 4. The sale is outright and definite. So, notwithstanding paragraph 15 of the judgment, we say the real dilemma today on the standard form wording is between whether there was an obligation to tender NOR and be ready to validly complete legal transfer of the vessel. From now on, I may just say be ready, a shorthand for that. 1, by the cancelling date, or 2, within a reasonable time.
We have to bear in mind, though, don't we, that this a long way from the actual Section 69 legal question that is posed. That doesn't mean that we can't look at other issues to understand the right answer to the question that's posed, but we would need to be persuaded that we need to answer that question in order to answer the Section 69 question.
Understood. And both parties say that the two grounds of appeal are independent, such that even if they lose on ground one, they can still win on ground two.
Yes.
But both parties also say, I'll be correct if I'm wrong, that their position on ground two is clearer still if they're correct on ground one. And so to that extent, ground one is a precursor to ground two. But I mean, your Lordship's point is reflected partly in the attempt I made to have a ground three, because what I submitted on the application for leave to appeal to this court was that the judge's change to the question was a change of substance, and that is related to this issue we're now arguing on ground one, and she said it wasn't a change of substance. But for the judge, certainly, ground one is also a precursor to ground two.
It's got to fall within sharpen material, hasn't it? Any change he makes to the question.
Yes, it has, and I do not have permission to appeal on the basis that her change to the question overstepped. But what I do say is that because I am right on both grounds one and ground two, alternatively just on ground two, I can prevail. And
well, if it was an improper change to the question, she didn't have jurisdiction.
Yes, and the court could then, of its own volition, I would say, revert to the original question on which permission was given by Mr. Justice Bright.
I mean, as I was a member of the court that was found in the Supreme Court to have improperly changed the question, it's an issue that I'm alive to.
Yes, I can see that. The second issue, which certainly does arise for decision even on the original question of law, is to what damages does clause 14b entitle cancelling buyers, and in particular does it extend to loss of bargain damages? Again, there appear to be three answers in play here. Answer one, we say it entitles buyers to losses resulting from the cancellation, including loss of bargain damages, on its ordinary and natural meaning. Answer two, sellers say, and this is their respondent's notice point 2 at core page 18, and in their skeleton paragraph 42 sub 3 at core 70, it only preserves buyers' existing entitlement to accrued damages. Answer 3, in the judgment at paragraph 45, core page 94, Mrs. Justice Dias rejected the buyer's limitation to accrued damages and expenses, that's 45 Roman 1, and held that it covered accrued losses and expenses which have crystallised at the point of cancellation, but not prospective losses and expenses caused by the cancellation.
She rejected the seller's limitation.
Yes, sorry, I misspoke. And the key word in 45 Roman 3 appears to be prospective. So while the positions of sellers and the judge are aligned that loss of bargain damages are off limits, they are not otherwise, as we understand it, aligned on what clause 14b does cover. More on that later. So the MOA, and please do speed me up, this is the second section of my submissions, is at core page 105. And if I'm going too slowly, yes, please do say. Page 105, we have the parties. Page 105, still line 19, we have the deposit holder, Hill Dickinson, Singapore, and that's relevant when we come on to understand the closing process. Over the page at 106, please, we have the purchase price, clause 1 of 15 million. And then we have clause 3 dealing with payment. There is a bespoke provision in relation to the buyers remitting the balance monies to Hill Dickinson Singapore. The standard wording then at lines 44 to 46 says that the sellers are to receive the deposit by its release and the balance of the purchase price on delivery of the vessel, but not later than 3 banking days after NOR. So the NOR is relevant here because it triggers a 3 banking day window in which delivery and also delivery of the delivery documentation are to be performed simultaneously with payment of the price, i.e. by way of concurrent performance. Page 107, we have the all-important clause 5. Clause 5a says the vessel shall be delivered and first deals with location.
Can I go back to what you said about clause 3?
Yes.
On the face of it, it looks like an obligation on the buyer to pay within 3 banking days. But your submission is that because of the words on delivery of the vessel, it effectively imposes an obligation on the seller to deliver within 3 banking days.
Yes.
Yes. Thank you.
Well, otherwise the buyer would have to pay without getting the
Without
vessel.
delivery.
Yes. They're classic concurrent obligations, as is.
It would have been clearer if it had said, within 3 days after notice of readiness, the sale will be completed, the seller will give delivery, and the buyer will pay the money. But that's effectively what it means.
Yes, and one has to understand the ways in which delivery happens. It happens in a physical sense, but it also happens in a legal sense. And the legal sense, at least, is clarified by clause 8 that we're going to come on to in relation to documentation. So clause 5 has the not before date of 20th July 2021 here, a month before the cancelling date. The cancelling date follows, like notice of readiness, it is capitalised but not defined. In parenthesis, however, the standard form has further information as to the cancelling date in clauses 5c, 6a, 1 and 3 and 14. Next is the laden voyage clause, the bespoke wording starting with however. Clause 5b, the express obligations to keep buyers informed of the vessel itinerary and to give particular dates of notice of intended tender of NOR. Then the obligation to give NOR when the vessel is at the place of delivery and physically ready for delivery in accordance with the agreement. Clause 5c caters for possible extensions of time. If, notwithstanding the exercise of due diligence, the vessel will not be ready for delivery by the cancelling date. Clause 5d is then a follow-on clause indicating that clause 5c events are without prejudice to any claim for damages buyers may have under clause 14. Obviously, we'll come back to clause 5. Clause 6 is relevant to the extent that it is referred to in parenthesis after the term cancelling date. Clauses 6a, Roman 1 and 3 have provisions for extension of the cancelling date in the event the buyers exercise their option to request an underwater inspection which requires the vessel to relocate, or subsequently, if the need for underwater works is found under Roman 2, requires the vessel to relocate for dry dock under Roman 3. Page 110, we have clause 8, the place of closing. So that's documentary closing, where documents referred to in the addendum will be exchanged by both parties respectively, is the lawyers' offices in Singapore, Hill Dickinson in Singapore. They are, it's not a coincidence, the deposit holder. The vessel documentation is then identified, or to be identified, in an addendum, and that documentation is to be exchanged for payment of the purchase price. So that reinforces the concurrent nature of the legal delivery obligation and the payment of the price. And this goes hand in hand with clause 3, that all happens within the 3 banking days of tender of the NOR. Page.
Can I betray my ignorance? What do you need to do to hand over physical delivery? Because I mean, this makes it clear that you have to hand over the documents, and right at the end of clause 8, you sign a protocol of delivery and acceptance. So that's all taking place in Singapore. What happens in the port where the ship actually is?
The protocol may or may not happen in Singapore or on the vessel, but the key to physical delivery is change of crew.
Change of crew.
And that was the problem with the first phase of negligence, with which we're not really concerned on this case. Because these being COVID times, the Chinese authorities had a rule that if crew were disembarked, they had to have an outbound flight from China before midnight on the day of their disembarkation. And flights were also hard to come by because the air wasn't full of airplanes during this period. And so that put an onus upon sellers to arrange relevant flights such that their crew could disembark and be replaced by the incoming crew. And it is the incoming crew who are in the employment of the buyers that effectively gives the buyers possession and control of the vessel.
That's like handing over the keys.
To a car. And presumably there will be some formal handover from master to master of each of those respective crews at the time of physical delivery. Still on clause 8.8d provides for exchange of copy documents 9 days prior to the vessel's intended date of readiness for delivery as notified under clause 5b, so that there aren't surprises within the 3 banking day window. And then clause 8e on 112 provides additional documentary obligations concurrent with those in the addendum, for example, in relation to the vessel's class certificates. Clause 11, now at line 314, the vessel shall be delivered free of cargo, etc., with her class maintained without condition recommendation. So that stipulates the condition that is required of the vessel at the time of delivery. Then on to the default clauses. Clause 13 is buyer's default. It has 2 separate limbs. The first limb responds to a failure to pay the deposit in accordance with clause 2. The second limb, starting at line 332, responds to failure to pay the purchase price in accordance with clause 3.
Does the fact that clauses don't use the word fail, whereas clause 14 does use the word fail, matter?
If
you just described them as failure, that's all. I noticed you said that, and I noticed they didn't say that.
If anything, that's a point in our favour, because it reinforces the element of breach, which we say underpins clause 14. But there is some similarity of wording, but not a complete overlap between clause 13b, shall be entitled to claim further compensation for their losses and for all expenses incurred together with interest, and the wording which is contentious today in 14b. Page 1.
Is lim 2 of clause 13 one of these clauses where even if you're 5 minutes late, that's it, the sellers can cancel? Or don't?
Yes.
Yes. It just says if you don't pay on time, then the sellers can cancel.
Yes.
And can the sellers claim from the buyers in such a case loss of bargain damages, or is that not clear?
That is not decided on
Not decided.
the authorities. Clause 14 will have been seen, and the judge and both parties refer to the two paragraphs as 14a and 14b. Finally, on the contract, we have at tab 11, page 117, the addendum of documents to be exchanged, and your lordships have obviously looked at that already. No particular document is essential for the purposes of the arguments today, but they reinforce what we've said about the 3 banking day window for documentary closing. Next is the award, and that is in tab 12. We have summarised the key findings in our skeleton at paragraph 10. The most important point to emphasise is that there were the 2 distinct phases of negligence. First, the disembarkation of crew problem for a delivery by 20th August, I just summarised. Secondly, the negligent failure to take reasonable care to make arrangements for delivery by the 15th of October after the extension of the cancellation date. For the purposes of this appeal, the first phase of negligence and the extension to the cancelling date are, we say, irrelevant. The outcome on this appeal should be the same as it would be if 15th of October had been the original cancelling date and there was only one phase of proven negligence. I only want to show, beyond the paragraph 10 summary, your lordships, the passage of the award dealing with this clause 14 point. They start at page 45 of the supplemental bundle. Paragraphs 152 to 156 summarise the parties' respective arguments before the tribunal. Tribunal analysis starts at page 47, paragraph 157. Paragraph 157 sets out the ground rules, and we say is unimpeachable. The first sentence, repudiatory breach is not a sine qua non to loss of bargain damages. That would exclude any clause providing for loss of bargain damages as a bespoke remedy. The second sentence, an option to cancel will not itself entitle the cancelling party to loss of bargain damages. That is common ground. We do not rely on clause 14a as creating that entitlement. The third sentence, entitlement to damages on top of cancellation depends on the terms agreed. Paragraph 158, the first sentence has been unfairly criticised by the sellers as appearing to have imposed a burden on the sellers. We say that's too meticulous a legal eye looking to pick holes. All the tribunal are saying is that the sellers' submissions were rejected. we say that paragraph 158 is also correct. Clause 14b makes this case distinguishable from cancellation clauses in charters. More on that later. Paragraph 159, as the judge said at judgment para 60, is incontrovertibly correct. Paragraph 160 emphasises, correctly we say, that there are two provisions here. First, the cancellation right, clause 14a, together with a right to compensation, i.e. 14b. It then says in the penultimate sentence that the sellers were in breach, which is obviously the issue under ground 1, where the judge has differed from the tribunal. Paragraphs 161 and 162 distinguish, correctly we say, time charter cancellation provisions, in particular on the basis that they do not also confer a right to compensation where failure is caused by proven negligence. The last sentence of paragraph 162 is critical for ground of appeal 2. It is the London Maritime Arbitration Tribunal's conclusion that on its ordinary meaning, the parties would have understood clause 14b compensation to extend to the consequences of cancellation, including loss of profit. Paragraph 163 expands upon that finding. The starting point is cancellation. So the tribunal is effectively saying that the final words of clause 14b are making clear that the compensation remedy also applies if the MOA is kept alive. And then in the final sentence, the tribunal called out the sellers for failing to put forward a satisfactory alternative explanation for what is covered by clause 14b. We say that problem persists. Paragraph 164, the tribunal relied upon the textbooks and what we say is the settled understanding as to the availability of loss of bargain damages. And then they reinforce their finding on the ordinary meaning of 14b, saying it would be inconsistent with the compensation wording not to allow loss of profits. 165 then sets out the key conclusions, including the tribunal's finding on causation, namely that the cause of the buyer's loss of profits, i.e. market damages, was sellers' failure to deliver, causing buyers to bring the MOA to an end. So I turn then to the third section of my submissions and start with ground 1. We say that sellers were under a duty, which is at least a duty of care, to tender NOR and be ready validly to complete legal transfer by the cancelling date. It is sufficient for our appeal to succeed if these are duties of care. So I will not seek to persuade your lordships that these are strict duties, although we say the debate is an arid one. See paragraph 4 of our skeleton. This is a pure question of construction. Our position is supported by 1, textual analysis, 2, commercial considerations, and 3, authority. The judge's reasoning on this at paragraphs 14 to 21 is wrong.
I understand that you focus on duty of care because the term negligence is used in clause 14, but it's very unusual to consider these type of contractual obligations in sales ships as being duties of care.
Yes.
It's not clear to me how a contract of sale could be comprised of duties of care. Surely there's an obligation, a contractual obligation to deliver that which is being sold and a contractual obligation to pay the price. And does it make any sense to analyse those in terms of duty of care?
That is the usual situation. And that is why in our skeleton we said that for the avoidance of doubt, we say that is the legally correct outcome. But there is an arid debate as between whether it is a strict duty or duty of care, because we can't conceive of an example where it would make a difference given the wording of clause 14b.
Well,
Because
I thought on the face of it, the way it works is that there is an obligation to deliver, or maybe strictly serve the notice of readiness to deliver, because that then imposes obligations on the buyer to be in a position to pay. And that is in 14a. Failure to comply with that gives the rise to the right to cancel. What 14b does is introduce another concept, is, well, in that context of a failure to perform the contractual obligation, was there a lack of reasonable care which led to it?
Yes.
That seems to be a fairly straightforward analysis of the contract.
Yes, and they are two routes to arriving at the same practical outcome, as far as we can tell, in all scenarios. One is a strict duty, but effectively the inability to recover any compensation for breach of the strict duty unless negligence is proven.
And we're not talking about strict duty here, we're talking about a contractual obligation.
Yes, and in that sense, though, what clause 14b does in effect is says that you will only have a monetary remedy if the breach of that contractual obligation was caused by proven negligence. And one can reach the same practical outcome either by having the contractual obligation and then the clarification of the limit on the monetary remedy, or allowing the limit on the monetary remedy to define the content of the contractual obligation as a duty of care.
That would be to let the tail wag the dog, wouldn't it? But just one reference to negligence in clause 14b turns the whole contract from a usual set of contractual obligations into an obligation to use care. That seems a very odd result.
Yes, and that's why we took the position we did in our skeleton. But what we do say is that the judgment is only correct if there is no contractual obligation. And that can't be right. The sensible debate is between a contractual obligation which appears absolute, but then is qualified in terms of remedies by clause 14b, or a duty of care. We say it doesn't matter to us which, and we can't see that it would matter.
Well, if there's no contractual obligation to do something, it's hard to see against what one is judging the standard of care. I mean, how can you say somebody hasn't taken reasonable care to have the vessel ready for delivery by a particular date if there is no obligation to have it ready by a particular date? Surely the context of the perceived duty of care, or the measure against which you assess whether reasonable care was taken, is against the obligation to do something, a particular thing by a particular date.
Quite so. And we say that the judge wrongly siloed clauses 5 and 14 rather than construing the contract as a whole in that way. In terms of the textual support, the first part of our case, the starting point, and we're back to clause 5 in the MOA, so page 107 core, It's the term cancelling date whose effect we are trying to ascertain. In the absence of a definition of that term, the closest we have are the indications in parenthesis immediately following the term that we should look to those other clauses to better understand the meaning of the phrase cancelling date. The clause 6 references only deal with diver inspections and dry dock extensions to the cancelling dates. So we are left then with clause 5c and clause 14 as the operative clauses that inform the meaning and effect of the phrase cancelling date. And that is then the point your Lordship just made about how if one is testing negligence, one needs a yardstick, and the yardstick is a contractual duty. So picking up in our skeleton at paragraph 22 on...
Just before you move on, is there any conceptual difference between duty to take reasonable care to do something and a duty to use reasonable diligence to do something? Are they just the same thing?
No, they're the same thing here. And
I mean, I think part of the difficulty, that certainly I have, is that duty of care just doesn't seem the right label. I know negligence is the contractual term, but normally when one's talking about duties of care, it's because the claimant is relying on the defendant to act in their interests in some way. You know, you engage a professional, you expect them to use reasonable skill and care. That's not really, as my Lord says, what you expect to happen when people are selling things to you.
no,
So, whereas diligence seems a much more usable label for what is really the same concept, which is that there are some things which if you can't manage to deliver in time, it's not your fault, you don't have to pay compensation. But if it is your fault, you do.
yes, and we say that works. The term exercise of due diligence in clause 5c and the term proven negligence in clause 14 are two sides of the same coin, just operating at different stages. The difficulty with clause 5c is that the rights and wrongs have to be determined in the heat of the moment because time is very limited. It's 3 running days within which buyers have to decide whether they want to accept the extension or not. And evidently, they're unlikely to be able to know exactly what has caused the failure.
The difficulty is 5C says you can only, as the seller, get an extension if you've acted with reasonable diligence.
Mm-hmm.
And then it says, but that's without prejudice to the buyer's right to claim compensation. But you can only claim compensation if it's proven negligence, in which case, how can you have acted with reasonable diligence? So,
well, in practice, the extension will often be agreed pragmatically.
well, without prejudice to the contention that actually you did have proven negligence.
It wasn't contractually justified, exactly, because a buyer still wants, certainly in response to a first phase of possible negligence, as yet undecided, to take delivery of the ship. So we say it doesn't matter whether one starts with clause 5 or 14 because they speak with one voice on this. And each time your lordships say, well, shouldn't it be more than a duty of care in contract of sale, we say, yes, that's fine for our case too.
Well, you may not be able to see a very definitive statement. The vessel must be delivered by X date. Mm-hmm. But you read all this together. Mm-hmm. And
yes, and one point to pick up though is that the cancelling date is not that date, because the cancelling date is tender of NOR and readiness to deliver, and then the 3 banking day window.
yes,
So, strictly speaking, the obligation to deliver would be within 3 banking days of.
but as in many contractual obligations, effectively the obligation is to tender for delivery. Mm-hmm. And it's not entirely within the seller's power to deliver, because it's dependent upon the purchaser paying.
And one does not have to follow through with delivery if the deposit holder doesn't have all the monies
Which is
referred
why
to.
you have the concept of notice of readiness, which is when the vessel is physically ready for delivery, and then you have a 3-day period during which the buyer must pay.
But it's legal readiness as well, because be ready validly to complete a transfer.
Physically and legally ready.
So, yes, I was just looking at 14A. There are two, well actually there's 3 triggers, but in the first sentence there's 2 triggers. Fail to give notice of readiness, or fail to be ready to validly complete a legal transfer by the cancelling date. The second limb of that doesn't mean you have to be ready. You have to be ready by the cancelling date. You don't have to actually complete by the cancelling date.
No, because readiness is the point at which readiness and NOR are required by the cancelling date.
So
3-day window.
If you look at the cancelling date of 20th of August, you can give notice of readiness on that day, so any time up to midnight, I think.
Yes.
So you can give notice of readiness at 10 p.m. on the 20th of August, and then the completion can take place within 3 banking days thereafter.
Yes, exactly. And the
But
obligation.
At the date at which you give notice of readiness, you have to be not only physically ready, you have to be legally ready. You have to have all your legal documentation in order.
Yes, and physical readiness is dealt with in 5C, and legal readiness is explicitly here in 14A. And so we say one can start with clause 5 or clause 14, it doesn't matter, they speak with one voice. I'll follow the order in our skeleton for convenience. There's a logically prior textual point to those we make at paragraph 23 and following. It may be that the court has already anticipated this. Clause 14, by defining the effects of failure in the way that it does, dictates or at least supports underlying obligations. This is the yardstick point. As a matter of construction, a duty can be expressed in at least 2 different ways. A contract may say simply party A must do X, but a contract may instead say, even if less elegant, if party A fails to do X, then it will be in default and will have to pay damages / compensation. The latter approach is reflected in clause 14. So we do say that paragraphs 14 and 21 of the judgment are where the judge incorrectly siloed clauses 5 and 14. Clause 14 is tied by its own terms and also by the reference in parenthesis after cancelling date to clause 5. Clause 14 cannot be read without reference to clause 5 and vice versa. Clause 14 provides a remedy in compensation or damages as it is also described in clause 5D. So where there is a monetary remedy, there is an underlying right. Buyers have the right that sellers will at least take reasonable care to give NOR and be ready by the cancelling date. Mrs. Justice Dias fell into error at paragraph 14 by divorcing the consequences of particular conduct from the conduct required. Paragraph 14 of the judgment also misconstrues or at least overstates the reference back to clause 5B in the first sentence of 14A. The full operative wording relating to NOR is should the sellers fail to give NOR in accordance with clause 5B by the cancelling date. So the words by the cancelling date qualify both the failures in respect of A, NOR, and B, readiness. Clause 14B, anyway, does not have a complication by way of reference back to clause 5B. So the alternative to having this duty, whether absolute or of care, is to have not only a cancellation right, but also a monetary right in compensation / damages without any relevant underlying obligation on sellers. That is, we say, incoherent and fundamentally inconsistent with the nature of the contract as a contract of sale. The seller's skeleton, paragraph 15, core, page 52, supports paragraph 14 of the judgment in saying that clause 14 cannot be the basis for any obligation. But when doing that, sellers only address clause 14a, the cancellation provision, and say nothing about 14b. In summary, the monetary remedy in 14b puts beyond doubt that there is a duty at least to take reasonable care to give NOR or be ready by the cancelling date. Picking up the narrower textual points at paragraph 23 and following of our skeleton. First, we rely upon the repeated use of the words fail and failure. We accept that in isolation, the word fail may or may not import the notion of fault, as per the dictum in my learned friend's skeleton, paragraph 17, 2a, core, page 58. The key is the context of those words within clause 14. In conjunction with the word default and the monetary remedy, it connotes, or they, fail and failure, connote fault by sellers. Secondly, we rely upon that heading of default. Again, we accept that the meaning of that word will depend upon its context, but we say the starting point is that the use of the word default in a contract connotes a failure to fulfill a legal requirement or obligation. That much was common ground before this court and approved in the case at Authorities tab 20, ABC Electrification Limited and National Rail Infrastructure, page 318, Authorities bundle. There was a contract for rail upgrade works that the employer could deduct disallowed cost, meaning any cost due to negligence or default of the contractor. It was held that the default covered any breach of contract and did not require blame or culpability. For now, I'll show your lordships only paragraph 58, Lord Justice Mayles, on page 328. In our contract, there is nothing to displace the starting point that default connotes failure to fulfill a legal obligation. We also say the heading can be taken into account here for the reasons in our skeleton at paragraph 25. The judge erred in paragraph 20 in saying the heading simply distinguishes sellers and buyers' responsibility. Buyer's default in clause 13 deals with two buyer breaches, failure to pay the deposit and failure to pay the purchase price, breach of clause 2 and 3 respectively. Conversely, seller's default in clause 14 deals with seller's breach in failing to give NOR or be ready by the cancelling date, or at least to take reasonable care to do that. Pausing here, both the judge at paragraph 21 and the sellers in their skeleton at paragraph 15.2 rely upon the griffon. We have that, and it is a case on clause 13, but it doesn't answer the question raised by my Lord Justice Nugee. The buyers had failed to pay the deposit in repudiatory breach of contract, and it was held that the sellers were entitled to claim the deposit qua debt or as damages, even though their market loss was lower than the amount of the deposit. It addressed only limb 1 of clause 13 because the failure had been to pay the deposit, not to pay the purchase price. The sellers rely upon paragraph 10 on page 140, But the point Lord Justice Tomlinson makes there is that Lim 1 gives a cancellation right for a breach, namely failure to pay the deposit, that might not otherwise clearly be repudiatory. So page 140, paragraph 10. Nothing there indicates the absence of an underlying obligation in clause 13, and we say there is no absence in clause 14. Our third textual point at paragraph 26 of our skeleton is that the judge fell into error at paragraph 16 of the judgment, and the sellers are wrong to continue to draw an analogy with time charter cancellation clauses. There are three reasons why this is wrong. A, such clauses do not use the language of failure or default. B, charter party cancellation clauses do not have, in the standard forms, a bespoke compensation clause. C, time charters do anyway include a relevant implied obligation that has to be performed by the cancelling date, and it's a duty of care. As to A, in footnote 37 of our skeleton, we refer to a number of time charter standard forms, and that's on core page 34. Excerpts of those are in the authorities bundle at tabs 32 to 38, pages 455 to 469. I won't go through them all. They all talk in a passive way about what happens if the vessel is not ready or similar. They don't have the language of failure. They don't have the language of default.
We're really straying a long, long way from this question on this contract when we start looking at standard forms of other contracts. And we've got to construe this contract.
Well, yes, we agree, and para 16 of the judgment was wrong to draw this analogy. This shows why it was wrong in terms of language. Point B shows that it was wrong because these time charter cancellation clauses don't have a bespoke compensation clause such as we have here in clause 14b, or any compensation clause. So the analogy is flawed at that level.
I call it bespoke. I must say I thought that it was called bespoke because it wasn't in the standard form Norwegian ship form thing, but it is in the standard form Norwegian ship form thing. So why is it?
Yep.
Why are you calling it that?
That's a fair comment. The word may be inapposite. The reason we have referred to it as bespoke is because a leitmotif of Seller's case is that, as a matter of law, a bare cancellation right does not give rise to a claim for loss of damages. So to a claim for damages, let alone a claim for loss of bargain damages. And so what we have done is use the word bespoke to distinguish this case from bare cancellation scenarios. But the word can be parked once that's understood. Point C, distinguishing the time charter cancellations, is perhaps the most important because actually it turns the analogy on its head. The analogy proceeds on the assumption that there is no relevant obligation tied to a cancelling date in a time charter. But that is not the law. There is generally an implied obligation to use reasonable diligence to deliver the vessel into the services of the charterer by the cancelling date. That is on the authority of Demokritos which is tab 8, page 53 of the authorities bundle. So in this case, the vessel's number 2 hold 'tween deck had collapsed such that the vessel was subject to a seaworthiness certificate as at the cancelling date under the time charter. It was held that the owners were under an implied obligation to use reasonable diligence to deliver the vessel in a fit condition by the cancelling date. They had used reasonable diligence, so there was no breach of contract. And the key passage is on page 56, authorities bundle. Middle of the left-hand column as highlighted.
Said to be of course.
To reinforce the general application of that authority, please may I also show you tab 27, page 416, which is from the 7th edition of the textbook Time Charters. And if one turns on to 417, the effect of a cancelling clause is set out. 7.5 on page 417, primary effect is to give the option to cancel. However, the clause has another effect. It imposes an implied obligation to exercise reasonable diligence to deliver the ship by the relevant date. So the Demokritos of general application. So insofar as there is an analogy here with time charter cancellation clauses, it supports buyers. We are saying that upon its proper construction, the MOA contains obligations to at least exercise due diligence to tender NOR and be ready by the cancelling date. A comparable obligation will be implied into a time charter by virtue of a cancelling date. Next, I turn to the textual points on clause 5, which we have at paragraph 27 and following of our skeleton. First, we rely upon the asymmetry. This is paragraph 29, having a not before date, which does include an obligation, a window up to the cancelling date, but the judge and sellers say no relevant obligation tied to the cancelling date. We say the natural juxtaposition is that the cancelling date is the date by which sellers must tender NOR or be ready. It is nothing to the point that buyers may not suffer any loss by reason of a premature NOR. The point is about a consistent overall scheme. The sellers are wrong to say that line 78 has relevant express wording where line 79 does not, because line 79 refers to clause 14, which brings in the points already made. At paragraph 30, we rely upon a number of sub-clauses of clause 5 as reinforcing the obligations, the clear-cut obligations to tender narrowing notices under clause 5b. While they do not bind the sellers to a particular date, they are most consistent with the existence of an obligation to tender NOR by the cancelling date. Lines 83 to 84 impose a mandatory obligation to tender NOR when the vessel is at the place of delivery and physically ready. That is most consistent with there being a positive obligation to tender NOR before the cancelling date. Most critically, in terms of the wording of the sub-clauses after the cancelling date phrase is clause 5C, because it's referred to in that parenthesis, and it posits that the sellers must exercise due diligence to have the vessel ready by the cancelling date, so at least a duty of care. The sellers say that is no more than a precondition to an extension of time. We say that takes the reference out of context. It ignores the reference to damages in clause 5D and the monetary remedy in clause 14B. Clause 5D, clear wording in favour of the duty. It posits a claim for damages. Damages claim presupposes a breach. Here, the damages claim will succeed, more or less in terms of quantum, depending upon ground 2, if there is a breach of duty of care. Judgment paragraph 17 is wrong to say that the wording of clause 5D means there is no question of breach. The reference to a claim for damages under clause 14 again refers the reader to clause 14 to understand the parameters of the duty. Whether the judgment is right in saying at paragraph 17 that no breach of contract is necessarily involved in failing to tender NOR by the cancelling date goes to that arid debate as to whether it's an absolute duty or a duty of care. And likewise, judgment 62 is wrong in saying in the penultimate sentence that there is a right to claim damages for a failure but not a breach. So much for the standard form. We say the laden voyage clause reflected how the cancelling date was understood as a drop-dead date, delivery immediately after current voyage, drop-dead date of 20th of August. The cancelling date was not just a milestone on the way to a more nebulous obligation to deliver within a reasonable time. Finally, we rely upon the title to clause 5. Repeatedly, the sellers make the point that it would have been straightforward for the parties to include wording making the position clearer. That's in their skeleton at paragraph 16.1c, 16.1d, 16.2b, 17.3 and 22. Those are why not say it submissions. They go nowhere, they just beg the question of the effect of the terms the parties did use. In every case of a construction argument, each party's position could have been achieved by different wording. Finally, on the text and ground 1, we say the judge also erred in the concluding sentence of paragraph 16. The flexibility is limited in relation to the extension of time. Clause 5C is only where sellers have exercised due diligence. And clause 6A1 provides for a pro rata extension to the cancelling date if buyers request a diver's inspection and the vessel is forced to relocate. 6A3 provides for a maximum of 14 days extension if the inspection discovers underwater parts in need of repair, in turn requiring dry docking. So that's not flexibility, it's a carefully circumscribed regime for limited extensions. Our second aspect to our case on ground 1 is commercial consequences. And this is where the dilemma arises starkly between the NOR and readiness obligations falling due by the cancelling date and those obligations falling due within a reasonable time. Our submissions are at paragraph 33 and following of our skeleton and are threefold. First, if the only obligation is to tender NOR and be ready within a reasonable time, then that obligation is at sea in what is otherwise a carefully time-specific sequence of events under clause 5. They start with the not before obligation in line 78. There then follows the clause 5b raft of obligations in terms of narrowing notices. But then, on seller's case, the uncertainty begins. Secondly, as mentioned already in relation to the word damages, buyers would be entitled to damages, aka compensation, for proven negligence without there being any breach of contractual duty. And we say that is uncommercial. The sellers say contracts can provide for payment on termination absent breach, but they do not point to any other example where there is negligence but not any breach of contractual duty. Thirdly, looking at the MOA beyond clause 5, if the obligation is only to make delivery within a reasonable time, and so tender NOR and be ready within a reasonable time, then that is also at sea in an MOA that otherwise has a carefully choreographed sequence of events. We have the clause 5 points that lead up to the NOR as identified. The NOR then triggers that 3 banking day process under clause 3 and all the concurrent obligations that fall therein. On the seller's case, the commencement of that 3 banking day window for closing is at large until the seller's tender NOR within a reasonable time. This is not about interdependence as such, but about consistency in what the overall MOA shows to be a time-critical process. That is the point that is missed in paragraph 19 of the judgment. The third and final aspect of our case on ground 1 is that the judge's decision is contrary to authority. We rely principally on the sole halt, both at first instance and in the Court of Appeal. We have to look at first instance, partly because it shows more of the facts, partly because it has led to what we say is settled market understanding, and also so that I only have to show your lordship these authorities once and not go back to them on ground 2. Tab 5, page 35, please. This is similar to the present case in that the sellers tried to squeeze in a further fixture in a lucrative market prior to delivery under an NSF MOA. They then failed to tender the vessel for delivery before the 31st of August cancelling date, and the buyers cancelled. It was held that the buyers were prima facie entitled to market damages under clause 14, but had failed to mitigate because they should reasonably have bought the ship at the contract price following their cancellation from the very same sellers. If we pick up, please, at page 39, right-hand column. Issue 1 was the equivalent of the issue in our case. At the bottom of page 39 is clause 14 of the NSF 1966 form. And in particular, one sees at the last sentence of that, the equivalent provision, the sellers shall in addition make due compensation for any loss caused to the buyers by non-fulfilment of the contract. Then we have clause 17 in that case. That provided the cancelling date of 31st of August. We say it was not materially different to clause 5 of our MOA. It did not in terms say the sellers must deliver by 31st of August, only that that was the cancelling date in buyer's option. Then please note, after the quote from the MOA, Mr. Pollock's first argument. That was similar to the judge and seller's position on ground 1, namely that the cancelling date did not provide more than a right of cancellation. One sees that dealt with in the final paragraph, left-hand column, starting with as to Mr. Pollock's first point. I must construe the contract as a whole. Clause 13 is a severe clause. It is not then surprising if clause 14 is equally stringent in the case of default by the seller. On its plain wording, it does give a right to cancel and to claim interest and compensation if the vessel is not delivered within the time specified. I cannot disregard the plain wording of the contract just because I thought, which I do not, that it leads to an unduly harsh result. So that's the equivalent of our issue on ground 1 being rejected. Mr. Pollock also made an argument which is the equivalent of our issue on ground 2, which was also rejected. For that, we go back to the left-hand column, and in the penultimate paragraph, after the reference to Home Office and Dorset Yacht, it says, thirdly, Mr. Pollock submitted that the clause only provided for loss caused by non-fulfilment of the contract. That means loss arising from the default and not from the loss of a bargain if the buyers are entitled to and do treat the contract at an end. That argument is rejected in the final paragraph, right-hand column, where Mr. Justice Staunton considers compensation for loss caused by non-fulfilment. I do not consider this must be confined to compensation for 3 days delay. Pausing there, that's the equivalent of the judge's position that one recovers loss of profits in the period between cancelling date and cancellation. The clause itself contemplates that the buyers may cancel and therefore that the contract will be wholly unperformed so far as its main object is concerned, that is to say, transfer of the property in the vessel. It is that loss which is, in my judgment, plainly provided for in the words loss caused to the buyers by non-fulfilment of this contract. So, finally, at the top of page 41, the prima facie position, subject to the issue of mitigation with which we have no comparison, is that the market price on the cancelling date was 5.5 million, the contract price was 5 million, prima facie market damages of 500,000. So compensation following cancellation under clause 14 of this prior iteration of the NSF form was held, 1, to follow a breach of contract by failing to deliver by the cancelling date, and 2, to entitle loss of bargain damages. Those were a ratio because they were necessary precursors to the decision that the buyers had then failed to mitigate and could nonetheless not recover the $500,000. The Court of Appeal decision is at tab 6, page 44. The only issue on appeal was mitigation, but the Court of Appeal endorsed the judge's position on these 2 points, which correspond to our 2 grounds. Page 46, please. Penultimate paragraph, right-hand column. Mr. Sumption had appeared for the buyers. His broad point was that the sellers were in breach of contract in failing to deliver the vessel by the due date. And then, moving halfway down the paragraph, if he cancels, the loss will be attributable to the seller's breach of contract and not to the cancellation. How comes it then that having cancelled the contract and suffered a loss of $500,000, the buyers are expected in effect to reverse their decision to cancel by entering into a new contract at the same price as the old, purely because it will eliminate their loss? So that was the submission. It was dealt with over the page 47, left-hand column, where the Master of the Rolls said, as we've already accepted as being trite law, the buyers had an unfettered right in this case to affirm or to cancel. No question of mitigation at that stage. They decided to cancel, and in consequence, they suffered a loss of $500,000. The next sentence is key. As a matter of causation, this loss, unless avoidable by some reasonable further action, was directly attributable to the seller's breach of contract. And then he goes on to deal with mitigation. Finally, in terms of authorities for ground 1, we rely on the textbook extracts at paragraphs 37 and 38 of our skeleton. Although it's fair to say that they do not consider as a possibility the argument that there is no obligation to tender NOR or be ready by the cancelling date. One of those is Strong and Herring. One author of that book, Mr. Herring, has since the judgment written an article on the judgment. We have that at tab 31, page 452. We rely upon it principally for its indication of industry understanding, consistent with the Solholt. So at page 452, just below the blue picture, the industry has long considered that a buyer could recover damages at large in such a situation. And then over the page at 453, first line of the conclusion, the result in this case is perhaps surprising given the industry prior understanding of what a buyer could recover as a consequence of a buyer's cancellation of the MOA where a seller's failure to give it an NOR has been caused by its negligence.
What is the role of industry understanding in construing a contract?
The role of industry understanding is important in circumstances where the parties have entered into the contract against the background of that understanding and of English authority at first instance and Court of Appeal in relation to what we say is materially indistinguishable wording on a prior standard form. So that's ground one. Unless there are any questions on ground one, I move on to ground two.
Shall we take our short?
Oh yes, thank you. Sorry.
We will keep it to 5 minutes.
What rise of table?
So granted.
This, again, is a pure question of construction. As the judge recorded at paragraph 35, Roman 2, it was below and presumably still is common ground that parties can add additional rights, e.g. a right to compensation, to what would otherwise be a bare cancellation right. In that context, discussion of financings of Baldock and Professor Peel's analysis of the termination paradox are not in point. They deal with bare cancellation rights. To that extent, paragraph 40 was right to marginalise them. We say the judge thereafter erred in her approach to clause 14 for the 4 reasons summarised at paragraph 43 of our skeleton. First, to set the scene, we say the judge erred in relation to the impact of the tribunal's findings on causation. The position in the judgment on the relevance of causation is confused and we say contradictory. Start by comparing paragraphs 53 and 54. At paragraph 53, this is core page 96, the judge does suggest, as the sellers point out, that her decision on losses recoverable under 14b is not dependent on her finding that there was no obligation. She merely says that the position is a fortiori if there was no prior positive obligation. But that is inconsistent with 3 points that are then made at paragraph 54 in distinguishing the authorities. At paragraph 54, when distinguishing the sole hold, the judge does so on the basis that in that case there was a positive obligation on the sellers to deliver no later than 31st of August. She says in the final sentence, accordingly, the Court of Appeal's acceptance that the loss caused by the cancellation was directly attributable to the seller's breach of contract was almost inevitable, given the finding the sellers were in breach of that obligation. That is inconsistent with paragraph 53 saying the issue of obligation is not determinative. Secondly, the same applies mutatis mutandis to her distinction of the al-Torfiq at paragraph 54, Roman 2. We'll look at that case shortly. Thirdly, at 54, Roman 5, the judge describes the reference to market damages under section 51.3 by Goldride, and then says the proposition is not controversial where the sellers are under a positive obligation to deliver by a particular date. Again, that is inconsistent with paragraph 53. So what is the correct approach here? The tribunal's findings are that the seller's failure to tender NOR and be ready caused the cancellation, and so caused the buyer's loss of bargain. Those are inviolable findings of fact, and we reiterate them at paragraph 47 of our skeleton with references. Therefore, it is only if clause 14 precludes recovery of loss of bargain in any cancellation scenario that the award was wrong to grant buyers those damages. The judge essentially accepted as much in the last sentence of paragraph 62 when saying, incorrectly on our case, that the tribunal's findings on causation were legally irrelevant. Contrary to what the sellers say in their skeleton at paragraph 33(1) on core 64, our case does not have to be a bright line that loss of bargain damages are always recoverable in the event of a clause 14 cancellation, let alone in the event of a bare cancellation. But where we have the tribunal's findings of factual causation all the way from the negligence through to the loss of bargain, we say such damages are recoverable. That takes us to our second point. In any event, the judge erred in relation to the language of clause 14b. Our submissions are paragraph 51 and following of our skeleton. The ordinary and natural meaning of due compensation for their loss and for all expenses covers market damages, as the tribunal held in paragraphs 162 and 164. There are 4 purely textual points to make. Number 1, the unqualified reference to loss covers loss of bargain. There is no reason in the text or the context to hold otherwise. Loss can cover expectation loss, i.e. loss of bargain. Point 2, sellers accept that if the clause said loss of bargain, our case would be right. But loss and all expenses is wider than just loss of bargain. Point 3, the word compensation is redolent of the compensatory principle. In a contract of sale where there is non-delivery, that finds form in section 51, Sale of Goods Act. And for this we rely upon the other point in Sharp and Vitera, which we have in the authorities bundle at tab 21, page 332. Buyers of lentils and peas, C&F FO Mundra, had failed to pay. The sellers repossessed in India, and the question arose as to how to assess their damages under the GAFTA default clause. It was held they were to be assessed ex-warehouse Mundra. For our purposes, the key passage is at 350 per Lord Hamblin, paragraphs 93 to 96. Sections 50 and 3 and 51.3 reflected the existing common law, including in terms of non-delivery. The available market principle is then referred to in the classic case of the Eleanor D'Amico. And then it is explained how, at 96, establishing damages in this way, market damages, is consistent with and reflects the compensatory principle. And that's what we say is engaged by the term compensation. So the position under clause 14b is analogous with section 51.3 Sale of Goods Act. The wide wording of clause 14b, compensation for their loss and for all expenses, provides no reason to consider otherwise or to limit.
Do you say this is a case that is actually directly covered by section 51?
Not directly, in that we are dealing with a contractual remedy rather than a claim at common law. But what we do say, similar to the industry understanding point in a way, that when construing the word compensation in this
compensation for loss
in this express contractual remedy, relevant background is the compensatory principle, which in the sale of goods context finds form in sections 50 and 51. So we say that in circumstances where it's due compensation for seller's negligence failures, a fortiori if they were breaches, it's the ground 1 point, that extends to the market damages. The fourth purely textual point is the reference to all expenses. We say that only reinforces the width of the clause. Moreover, the fact that wasted expenses may be recoverable under all expenses leads to the need to give separate content to the word loss. And that is best done by it encompassing loss of bargain. So we turn then to the judgment and where it went wrong on the text. Paragraph 45, please, on core 94. We support paragraph 45, Roman 1. The clause covers compensation caused by the proven negligence, applying the usual rules. Seller's skeleton, paragraph 42, sub 6, sets up a straw man. We do not say that the usual rules of remoteness, mitigation, etc. do not apply. Where we say the judge erred is not following through from 45 Roman 1. In particular, 45 Roman 1 and 45 Roman 3 are difficult to reconcile. 45.1 correctly rejects seller's case that the clause is only dealing with accrued damages otherwise recoverable in any event. And that's the respondent's notice, point 2, page 18 of the core. Next, at 45 Roman 2, Mrs. Justice Dyers correctly ties the failures to the tender of NOR and readiness, but that begs the question of what loss is recoverable. The first sentence of 45 Roman 3 is fine, but we say the loss of bargain is caused by the failures. Or at least it is open to the tribunal to find as much as it did. The cancellation does not break the chain of causation between the failure and the loss, as it might otherwise do in a bare cancellation case, such as financings in Baldock or phones for you. Pausing there, the central error in the seller's approach is that they repeatedly address that issue of whether a party can claim loss of bargain in a bare cancellation right scenario, which is irrelevant to, or at least not determinative of what clause 14b means. 14a, cancellation clause. 14b, compensation clause. The issue is not does 14a give rise to loss of bargain damages, it does 14b. So the sellers cannot impose upon 14b a solution that would apply in its absence to 14a. That risks failing to give 14b content. The sellers, we say, do fail to give 14b content. Back to the judgment. The second sentence of Roman 3 is where the judge begins to fall into error. She says, prima facie, this is a reference to accrued losses and expenses crystallised at the point of cancellation. But this cannot be only in accrued damages because she has rejected that limited case of the sellers at Roman 1. So it must be some of the losses and expenses caused by the cancellation, just not the prospective losses and expenses caused by the cancellation. The third sentence then reverts to saying that the compensation ought to be the same irrespective of cancellation. Insofar as that relies on the final words of clause 14, that is not what they say. They only say that the remedy exists whether or not buyers cancel, not that the losses must be the same in either event. But anyway, that third sentence of Roman 3 would suggest that the compensation cannot include any costs wasted by the cancellation, which would not otherwise be wasted absent cancellation. That third sentence implies a parity of recovery, cancellation or not. But that is then contradicted, it seems, by paragraph 48. The fourth sentence of paragraph 48 starts on the construction above, referring back to 45. The recoverable damages under clause 14b include expenses incurred by the buyers in making arrangements to crew the vessel, carrying out inspections, legal costs and preparing for delivery anyway. But none of those costs will be wasted if buyers do not cancel. None of those costs will be wasted if buyers take late delivery. By positing recovery of those costs at paragraph 48, the judge is positing recovery of losses caused by the cancellation, albeit perhaps on the arbitrary basis that the costs were in fact incurred prior to the cancellation rather than prospective, even if they were only wasted because of the cancellation. One is left unclear, trying to compare 45 and 48, as to what the judge is saying clause 14b does cover. And so the judge has not answered properly the problem on which the tribunal called out the sellers as to what clause 14b does cover, if not loss of bargain. For the judge, it covers some costs wasted by reason of the cancellation, but not the loss of bargain itself. So it appears to be an arbitrary cut-off in terms of what has crystallised, perhaps what has been incurred prior to the cancellation. That has no basis in the word. The sellers try and defend this at paragraph 46 of their skeleton. They say expenses wasted as a result of the cancellation are recoverable because clause 14b refers to all expenses. There is a suggestion that this is the distinction the judge has in mind at paragraph 56, third sentence, where she refers to there being no great injustice in limiting recovery to accrued losses and wasted expenses. Although that does not sit with 45 Roman 3 and the apparent parity of recovery. But that answer would suggest a different causation requirement test as between, on the one hand, loss, and on the other hand, all expenses. There is no support in the wording for that. It puts a weight on the word all as creating a causation dichotomy, which that word cannot reasonably bear. The causative wording is the same following both loss and all expenses, namely due to the proven negligence. So there is no justification for treating the causation requirement differently as between, on the one hand, loss, and on the other hand, all expenses. We say the indefensibility of paragraph 45 Roman 3, which refers to both losses and expenses throughout compendiously, is reflected in the seller's skeleton at paragraph 45. The sellers do not, as we understand it, defend 45 Roman 3, but instead revert to their accrued damages submission, which is Respondent's Notice point 2, 45 Roman 1. So the judge's solution has no textual foundation and leads to arbitrary and unjustified distinctions. Finally, on this part of the judgment, paragraph 46, clause 5D is neutral as to what clause 14B does cover. It is neutral as to whether damages caused by the failure to be ready by the cancelling date can extend to loss of bargain. We look to the wide wording of clause 14 for that. Beyond that, there are 3 complaints made by the sellers about our case on clause 14B I want to address. The first, in their skeleton at paragraphs 30 to 33, core 63, they say our case means clause 14B creates the equivalent of delivery by the cancelling date, NOR readiness by the cancelling date being a condition, whereas the award and the judgment both held it was not a condition, and that is not under appeal. That is a false equivalence, and paragraph 42 of the judgment is also wrong to that extent. If the MOA made tender of NOR or readiness by the cancelling date a condition, then any failure would be repudiatory and entitle buyers to loss of bargain clause damages. Clause 14 is not so strict. It provides that compensation may only be recovered where there is proven negligence causing the relevant failures. That proven negligence is required shows there are no draconian consequences of including loss of bargain damages. My learned friend refers to venial administrative errors. Venial errors are not negligent. And so we aren't creating a mirror to the situation if the obligations were a condition. Secondly, and relatedly, the sellers say in their paragraph 35 that clear words are required to create a loss of bargain remedy that would not otherwise exist at common law pursuant to 14A. The judge was right to reject this at paragraph 38. In any event, we say it's wrong. The question of construction of the damages clause at 14B is not approached with any such presumption. 3 points on the authorities. First, financings and Baldock. This is the limit of its relevance to our case. Lord Justice Diplock at page 23 of the authorities bundle says at the top of the page, pursuant to a cancelling option, whether the contract does more than this and confers any other rights or remedies on either party on the termination of the contract depends upon the true construction of the relevant provision, no more or less. Bungi and Nadira next, please. That is tab 15, page 144. This was, again, the GAFTA default clause. And if we turn on to page 154, at the bottom of paragraph 24, we see Mr. Rainey's submission on the express damages clause. The express damages clause is a better phrase than bespoke damages clause in this context. He said there's a strong presumption that an express damages clause is not intended to depart from the compensatory principle applied in the Golden Victory, etc. That argument was rejected at 26, and instead, Lord Sumption said in the final few sentences starting at letter E in the margin, I would accept a more moderate version of Mr. Rainey's presumption. A damages clause may be assumed in the absence of clear words, not to have been intended to operate arbitrarily, for example, by producing a result unrelated to anything which the parties can reasonably have expected to approximate the true loss. So on House of Lords authority, the only relevant clear words principle is that clear words are required for a bespoke damages clause to operate arbitrarily. There is not a clear words principle, as sellers say, that clear words are required to create a right beyond the common law. And
You said House of Lords, but I think it's actually Supreme Court.
yes, thank you. And it, contrary to my learned friend Skeleton at paragraph 34, sub 2, the House of Lords did not approve any other clear words principle from Novison and Alimenta. Third authority, I don't need to go there. As to the Spar Capella, paragraph 39 of the judgment was right that Mr. Justice Popper was not addressing an express damages clause. There is also no hint of any clear words requirement in the Court of Appeal decision in the Spar Capella. Thirdly, the sellers, for example, at paragraph 38 on core 67, now on 14b, make more why not say it submissions. Again, they just beg the question. The third aspect of our case on ground 2 is that we say the judge's decision is uncommercial. This is our skeleton at paragraphs 55 and following. There is a logically prior point as to the parties' commercial intentions to the ones set out there. The parties had provided a cancellation right. In the event of cancellation, buyers will lose their bargain, a bargain they would have performed if there had been prompt NOR readiness. Absent proven negligence, they will nonetheless have no claim under clause 14b. In the event, however, that the cancellation was a reaction to NOR or readiness failures caused by proven negligence, the dilemma is whether the parties intended the loss of bargain to fall on the negligent sellers or still to fall on the innocent buyers. We say it is uncommercial for the negligent sellers to escape liability in that scenario. The most or the more probable commercial outcome is that the parties intended the loss of bargain to be allocated to the negligent wrongdoer. Proven negligence was the fulcrum used by the parties to determine the allocation of risk of the buyer's loss of bargain. Turning to the further commercial points in the skeleton, the first is paragraph 56. That's the point that it's not clear what compensation actually covers if it's not, or what loss covers if it's not loss of bargain. That's paragraph 48 of the judgment. I've criticised the point on expenses. Otherwise, it said one can recover the loss of profits between the date when the vessel should have been delivered, absent negligence, and the cancellation. That is clear, at least in terms of a head of loss. But it is a very limited entitlement for which an evidential battle proving negligence is likely to be disproportionate given the need for prompt cancellation. A few days loss of profits, and one has to go to arbitration to prove negligence. And what is effectively said there is that the cancellation acts as a stop loss in terms of what is recoverable, ignoring the buyer's loss of bargain in fact suffered. As to the seller's case on what clause 14b does cover, their respondent's notice, it's accrued damages. At first sight, that might appear to make 14b surplusage. Accrued damages claims are existing causes of action. So why have clause 14b? On a proper analysis, the effect of seller's argument would be more subtle. Their argument would make clause 14b a pure exclusion clause. Accrued damages claims would have been recoverable as existing causes of action absent clause 14b, but now proven negligence is required. If we look at how sellers put this, specifically in their skeleton at paragraph 42.3 on core page 70, they say clause 14 preserves claims that would otherwise be lost where there was no proven negligence. That does not work for three reasons. First, if they are accrued damages claims, then they would not be lost otherwise, i.e. absent clause 14b. They don't need to be preserved, they're accrued. Secondly, nothing is preserved unless there is proven negligence. Proven negligence is now a hurdle to recover any compensation. Thirdly, if the sellers are right on ground one, what are the accrued damages for failure to tender, NOR, or be ready? On their case, there is not even any obligation, so nothing can have accrued. Obviously, we say there is an obligation. So the sellers are left to say, paragraph 47, sub 3, that clause 14 still provides a valuable right, namely cancellation. But again, that's just 14a. It provides no real content to 14b. So neither sellers nor the judge's construction makes commercial sense. The clear and straightforward construction, the answer found by the tribunal, that 14b extends to loss of bargain, makes commercial sense. Our next and final commercial argument is paragraph 57 of our skeleton and is about imbalance. Loss of bargain damages only arise in a rising market. In that event, by reason of their negligence and buyer's cancellation, sellers have a more valuable ship on their hands than if they had exercised due care and tendered NOR promptly, etc. So cancellation in the face of even a negligent seller would be foolhardy. It is no answer to say that buyers should just persevere, keeping alive the MOA with their negligent counterparty. Paragraph 57 of the judgment is wrong to assume the buyers will do that. That does no more than reflect how, on the judge's position and the seller's case, clause 14b has no real value. Here, the buyers had given once negligent sellers a second chance, only to find them negligent all over again in a different way. The fourth and final aspect of our case on clause 14b is that we say the judge's decision is contrary to authority, which cannot or should not be distinguished. This is primarily the Solholt. I won't show you that again. I will instead show you an article by Professor McMahon written after and criticising the judgment below, in particular by reference to that authority. His article shows more clearly and distinctly than I could the errors in paragraphs 49 and 50 of the judgment in terms of the overemphasis the judge put on the changes in wording from previous NSF forms. Authorities tab 30, page 447, please. The first paragraph sets out three uncontroversial principles. The final paragraph of the introduction supports our position, particularly in light of the Saleform's history. A reasonable reader would likely assume due compensation for loss and all expenses includes loss of bargain damages. That's the point made in answer to my Lord Justice Nugee. Over the page, onto page 449 in the comment, the first paragraph makes a number of points on the surprising aspects of the judgment, and then the next paragraph goes on to say, crucially, this is not the first time the courts have pronounced on how to calculate compensation for seller's default under the Saleform. continuing over the page to 450, after introducing the Solholt and other cases, the middle of the page has the paragraph starting with while, and that makes a number of points that we say correctly demonstrate why the Solholt should not be distinguished in relation to clause 14b. In summary, the wording has changed, yes, but there is no reason to think that the changes were intended to exclude loss of bargain damages where they were previously recoverable, in particular by way of deletion of the words for non-fulfillment of the contract. And then at the bottom of page 450, the point is reinforced about it being foolhardy to cancel, and contrary to what the judge says, Professor McMahon says that buyers may often wish to cancel and keep the benefit of the bargain when they no longer trust negligent sellers. So all the further authorities are consistent with a settled understanding that loss of bargain damages are available pursuant to a clause 14 NSF cancellation. The next is the al-Tawfiq. This is pertinent because it led to the introduction of the negligence qualification as recorded in footnote 5 to paragraph 54, Roman 3 of the judgment. We have this in the authorities bundle at tab 7, page 50. The vessel was delivered late following a grounding for which the sellers were blameless. The buyers did not cancel in this case, but they were held entitled to damages for late delivery. Although the buyers did not cancel, there were key dicta explaining how clause 14 was to be understood, both from the Tribunal and from Mr. Justice Lloyd. So at the top of page 51, right-hand column, there is the delivery clause. Malone Friend would say that's clearer wording in terms of the delivery deadline being an obligation. Then clause 14, which is similar to what we saw in the Solholt. On page 52, one then has an excerpt setting out the arbitrator's understanding of clause 14. Clause 14, however, it starts about halfway through that excerpt. However, clause 14 provides that the delivery date is missed for reasons which the sellers are responsible. Then if the buyers cancel, they can obtain damages for the loss of their bargain. We hold, therefore, that the sellers are obliged to deliver the vessel on or by 31st October, and if they fail to do so, they would in principle be liable for damages. And then the judge endorses that with additional explanation. There are further authorities which we set out on this point in our skeleton at paragraph 58, Parbolg and the Île aux Moines. In the interest of time, I won't take your lordships to them. I do accept that that important law, the law of diminishing returns, sets in as one goes down the list of authorities. None of them is as important as the Solholt or even the al-Tawfiq, but they are all consistent with an understanding of the recoverability of loss of bargain damages in the event of termination of a NSF MOA. The final authorities are the two textbooks, which are at paragraph 59 of our skeleton, and again they are clear that in the case of Strong and Herring, and assume in the case of Goldrine, the recoverability of market damages in a cancellation scenario. So unless there are any questions, those are my submissions on the appeal.
Can I just be clear? I think you did say this right at the outset. If we were against you on ground one, how does that affect your argument on ground two?
It doesn't. So, ground two is
I think you said it made it weaker.
No, I didn't.
Okay,
No, maybe
if you won on ground one, it made it stronger.
If I won on ground one, my argument on ground two was beyond doubt. Yes, I see the converse. Ground two is an independent ground of appeal. As I said, we agree that much as common ground. That's my learning friend's skeleton, paragraph 28. So we can succeed even if your lordships are against us on ground one. That is because clause 14b is an express damages clause.
Is it too simplistic to say the only question we have to decide is what due compensation for loss in 14b means?
It is the ultimate question, and if your lordships are in my favour anyway on that point, then I would not press for a finding on ground one. But we do say that the judge erred on ground one,
yes.
And since this is a question of general public importance, that was conceded at the Section 69 permission stage. The market might benefit from the matters on ground one being reset. But
at the moment, what I'm struggling with is I'm not sure what practical difference it makes to anybody whether we say that if we're with you on ground two, whether we say that there is, on the one hand, a contractual duty to give notice of readiness by the cancellation date, which is either an absolute duty but you're not liable if there's no proven negligence, or it's a duty to act with diligence or whatever. What practical difference it makes between that and saying, no, there's no breach of duty, but nevertheless, in a case of proven negligence, you are liable to make compensation, because it seems to be common ground that you can have a contractual provision which says that if A doesn't do something, even if it's not a breach of contract, then B can cancel and can claim compensation.
if your lordships are in my favour on ground two, then we don't need ground one. And that is...
And if we're against you on ground two, then ground one doesn't matter.
Well, I'm not sure that follows. Just on the former scenario, if you're with me on ground two, then the debate on ground one becomes a further tangent on what I've said is the arid debate as between strict duty or duty of care. But if you're against me on ground two, what is said by my learned friend as the exclusive remit of clause 14b and by the judge as part of it, but she appears to bolt on expenses caused by the cancellation, if not prospective, is that there are accrued damages claims. And so if you're in their favour on ground two, then that begs the question of what the accrued damages claims are, which in turn requires resolution of whether there were prior obligations.
Yeah. Thank you.
Thank you very much. Mr. Wright.
My Lords, this appeal against the careful decision of an experienced shipping judge should be dismissed. The outcome for which the appellant's buyers contend, we submit, would be draconian, inconsistent with the terms and scheme of the MOA, and wrong in law. I will develop submissions on both grounds of appeal, but as my Lord Justice Nugee has debated with my learned friend, the heart of this matter is really to be found in ground two, and whilst ground one is an important staging post to that analysis, and indeed it is part of the analysis adopted by the judge, rightly we say, ultimately this case will stand or fall on ground 2. And by way of opening salvo, we say that were the appeal to be allowed on that ground, it would be surprising and unfortunate for 2 important reasons that are at least now common ground. The first is the long-established distinction between, on the one hand, contractual rights of termination and cancellation, even where the exercise of those rights is as a matter of factual causation caused by breach. And on the other hand, repudiatory breaches of contract that entitle the innocent party to discharge the contract and claim damages at common law. And as we will see, this is not solely a matter of causation. In fact, all of the authorities make clear this distinction that we have drawn between accrued rights for non-repudiatory breaches prior to the termination, which are recoverable, and claims for loss of bargain damages, which are not in those circumstances. There is nothing arbitrary about the cut-off put forward by my learned friend. It is in fact settled law. The buyers indeed do not quarrel with that general proposition, which was ultimately common ground before the judge as recorded at paragraph 35. But much of their analysis, particularly on the causation side, is predicated on an erroneous assumption that if, 1, there is a breach of contract, and 2, that leads as a matter of factual causation to the exercise of a contractual right of termination or cancellation, then 3, the ordinary compensatory principle would entitle them to loss of bargain damages. And that is at one of the submissions at the heart of what they say on clause 14b, because one of the points that is made in their skeleton, paragraph 52, and repeated by my learned friend this morning, is that he says that his construction of clause 14b is consistent with the compensatory principle. We say not at all. It represents a significant departure from the compensatory principle that has to be clearly justified, and we say justified by clear words. My learned friend was asked, again I think by Lord Justice Nugee, do you have a claim under section 51 of the Sale of Goods Act, to which he correctly answered no, and the reason he doesn't have one is because non-delivery for the purposes of the Sale of Goods Act is a subspecies of repudiatory breach. As the judge rightly analysed, this is not a case of non-delivery within the meaning of the Sale of Goods Act. This is a case of delayed delivery that was then overtaken by the exercise of a contractual right of cancellation. The second point of now common ground is that it was not a condition of the MOA to tender NOR or be ready to validly complete legal transfer by the cancelling date, nor even was it a condition to exercise some contractual duty of care to take those steps. And this, in my submission, is important. If we go back to the Tribunal's own reasoning at page 47 of the supplementary bundle, my learned friend showed you some of paragraph 157. But he omitted to refer to the final 2 lines in which the Tribunal recognised that the simplest method by which a party could attach loss of bargain damages to a contractual termination right was to make it a condition. and is, as was common ground before the judge, whether or not the parties have indeed made a term a condition is a matter of construction.
But how would that work with the concept of negligence?
You would say the sellers shall exercise due diligence to deliver by X date. This is a condition of the contract, and failure will entitle you to terminate and claim loss of bargain damages. That's one formulation. So as we submitted at paragraphs 8 and 9 of our skeleton, one ends up with a fundamental oddity at the heart of the buyer's case. The parties, by the terms of their contract properly construed, have not made any obligations, even if one is to assume against me on ground one that there were obligations at all. But even assuming that there were obligations at all, it is now common ground that they were not conditions, even attaching to the supposed reasonable care obligation. But, so it is said, they have replicated the most important incidents of conditions by stipulating both a right to terminate and a right to claim common law damages. So again, the question that arises, and my learned friend respectfully hasn't grappled with, how is his case different to one in which the parties had expressly made a reasonable care obligation a condition? And there is no answer to that, because there is no practical difference between those two. And one then imports all of the reasons why the judge rightly found that the parties did not agree that the putative obligations were conditions. In particular, the visiting of draconian consequences upon a seller for a venial act of negligence, meaning that the cancelling date might be missed by a matter of hours. And then friend suggested that any act that was negligent would by definition not be venial. And again, one can posit a situation where, due to administrative error, the document isn't filed before the end of a working day, it's filed at the beginning of the following day. That is a legal impediment to delivery, which is resolved within a matter of hours. But on my learner's friend's case, if between midnight and open of business his clients were to cancel, they would not be only be entitled to cancel and claim for accrued damages, they would be entitled to loss of bargain damages. And we say that that is most unlikely to be what the parties intended. So, my lords, with that, and by way of opening salvo, the structure of the balance of my submissions, I propose first of all to analyse the MOA, and in particular consider rather closely the provisions of clauses 5 and 14. I then propose to deal with the two grounds in turn, although of course I will have addressed many of the textual points when looking at the MOA. I don't propose to deal separately with the respondent's notice, because we say that that naturally fits within the responses to the grounds of appeal. So, my lord, if we can take up the MOA again, and that is in page 105 of the core bundle. And I propose, if I may, to go straight to clause 5, which is at page 107. The first matter that is relied upon by the buyers is simply the heading and time and place of delivery and notices. That is an entirely neutral point. Clearly, the subject matter of the clause, in a very general sense, is the time and place of delivery notices, but that entirely generic description doesn't really advance the analysis one way or the other. Then clause 5a, the vessel shall be delivered and taken over safely afloat at a safe and accessible berth or anchorage, and then the proposed place of delivery is given, that clearly does impose, by way of express stipulation, obligations as regards the place of delivery. And importantly, the language used in that clause is consistent with the language of obligation. The vessel shall be delivered at a particular place, and as the judge observed, and I submit to this court, one nowhere sees any equivalent language when it comes to the time of delivery in the standard form. So where Malone and Friend submits in his skeleton that it would be anomalous for there to be an obligation as regards place, but not time, one of the answers we give to that is just that is simply a function of the different language used. And indeed, as we explain in paragraph 20 sub 3 of our skeleton, in shipping contracts, because of inherent uncertainty, there may be very good reason why the parties do not agree strict time obligations. One then takes lines 78 and 79. The first is the not before date, and Malone and Friend submits that given that that undoubtedly is an obligation not to tender before the 20th of July, that the lines would operate, as he puts it, asymmetrically, if I were right. The first and most obvious difficulty with that argument is that the parties have used different language. Notice of readiness shall not be tendered before 20th of July, and one sees no equivalent wording qualifying the cancelling date. Nor can one get the wording with the references into clauses 5C, 6A, or 14, that is simply pointing to other clauses in which reference to cancelling date arises. But there is a second point, which in many ways is more fundamental. The purpose of the not before wording is to ensure that the buyer does not have to take delivery in advance of the delivery window. So a buyer that isn't ready, doesn't have its financing in place or whatever, is entitled to reject a notice tendered before the 20th of July as premature. The intention of the not before wording is not to create some right in damages, at least primarily, but ensuring that the buyer does not have to take delivery before the opening of the window. The question then arises, what stops the buyer from having to take the vessel late after the window has closed? And the answer to that question is the fact of the cancelling date and the fact of the cancellation right. The buyer may choose to cancel once the cancelling date has expired at its election. It doesn't, in those circumstances, have to take the vessel later than it would wish. If one focuses on the primary obligation of deliveries and payment of the purchase price, rather than seeing everything through the prism of damages, there is in truth no asymmetry at all. There is simply a 1 month window before which the buyer is not obliged to take delivery because of the not before. After the window, again, the buyer is not obliged to take delivery because it may cancel. And that is also the answer to many of the points that Malone and Friend made about commercial certainty. He said, well, it's important that the buyers know where they stand. Do they have to take the vessel? Do they have to arrange for financing? When do they have to pay? But the point that I make, and indeed the judge made, in the context of the condition argument in particular, is that that element of commercial certainty, the performance element, is given by her construction and my construction, because the buyer still has that right to terminate, which is, of course, one of the important incidents of a condition at common law. And all of those points would hold good even on the printed form. What makes this an even more difficult case for the buyers on the wording of this MOA, and whilst I appreciate that this matter comes before this court as one of general public importance, one is ultimately construing this particular contract, is the laden voyage clause. Now, my learned friend opened his submissions by saying there were 3 answers that were given. And the answer that he imputed to us was, I think, quotes, leaving aside the laden voyage clause. But of course, that's not permissible. One is construing this contract, which does have the laden voyage clause. Far from assisting the buyers, this is a bespoke clause, in the true sense, that undermines their case. Why is that? First of all, it shows that at least in this MOA, the parties specifically addressed their minds to the question of time of delivery. But what they did not do is frame that time obligation by reference to the cancelling date. Instead, they framed it by reference to completion of the present laden voyage. And indeed, that is a time that may be either more likely before but potentially after the cancelling date. So one obvious problem that immediately presents the buyers is when in truth they say delivery has to be effected. Plainly on any view, it has to be effected immediately after the present laden voyage. But if Malone and Friends' case is that it also has to be delivered by the cancelling date, one ends up in this most commercially bizarre situation where you have 2 parallel obligations to deliver. We say rather, reading the 2 together, the better construction is that the obligation is to be found in the laden voyage clause, but then superadded to that there is a cancelling right. For example, if the laden voyage overruns for reasons for which the sellers are not at fault, the buyers nonetheless have the certainty given to them by the cancelling date. They can say, we're not going to wait for this laden voyage to be completed. We are simply entitled to cancel on the 20th August.
I'm not sure I agree with that. It seems to me the laden voyage clause is obviously directed to the fact that although the vessel is due to arrive on or around the 18th of July at the specified port, the cancellation date isn't until the 20th of August, and that clause is inserted to make sure that the sellers don't undertake another voyage.
Well, it may, as I say on the facts, end up bringing it forward. But the point I'm making is, in circumstances where the parties have expressly considered the timing of the obligation of delivery, that is the clause that contains the time obligation.
Forgive me, it's anticipated it will arrive on the 18th of July.
Yeah.
But they can't tender readiness until the 20th of July.
Yes.
So it cannot mean immediately in a strict sense, can it?
They would have to wait until at least the 20th of July.
Well, what it means is once it's arrived back, or once it's arrived at Qingdao, it will be prepared for sale, for delivery.
I agree with that.
But it seems to me that the plain legal and commercial purpose of that clause, inserted as a bespoke clause, is to stop it sailing off again on the 19th of July. It doesn't seem to me that that is creating some sort of extremely vague express delivery date obligation. It seems to me that the delivery obligation, as you say, is that there is a window created between the 20th of July and the 20th of August. And the question is whether or not there is an obligation to do so by the cancelling date.
Yes.
You say there isn't.
Yes.
Mr. Lewis says there is.
He does. But in the context of this clause, of this contract, I do rely upon the fact, certainly, that the parties have addressed their mind to these questions of delivery. And what I would add to that is it does make it very difficult for the buyers to deposit some implied contractual duty to exercise reasonable endeavours.
When do you say you were obliged to deliver by?
We were obliged to deliver immediately after the present laden voyage, subject to the caveat that we were not entitled to tender notice before the 20th.
And when did the laden voyage come to an end?
I would need to check my lord.
Because in fact you arranged another voyage in breach of the clause.
We did in fact, but there was a separate claim for damages for breach.
I understand that, but there must be, is there not a finding by the Tribunal as to when that voyage did in fact come to an end?
Yes. I've noticed at times that maybe we can check that over the lunch adjournment. I'll come back.
Oh, is that a convenient moment? Very well. We'll sit again at 2.
What, by the table?